Greetings to all. Welcome back to our YouTube channel. Myself Sanchita Sanand, a first year law student from Galgotia's University and currently working as a legal intern at LEXIS and Company. So today I'm here to talk about the Equal Remuneration Act of 1976. So basically in today's globalized era, women form an integral part of the Indian workforce. In such an environment, the quality of women's employment is very important and depends upon several factors. The foremost being equal access to education and other opportunities for skill development. This requires empowerment of women as well as creation of awareness among them about their legal rights and duties. In order to ensure this, the Government of India has taken several steps for creating a congenial work environment for women workers. A number of protective provisions have been incorporated in the various labour laws. Article 39 of the Constitution of India envisages that the state shall direct its policy, among other things, towards securing that there is equal pay of equal work for both men as well as women. To give effect to this constitutional provisions and also to ensure the enforcement of ILO Convention, the Equal Remuneration Act of 1976 was enacted by the Parliament. The Equal Remuneration Act 1976 provides for payment of equal remuneration to men and women and help prevent gender discrimination. So basically the two most important definition of the act are, first of all, what is a remuneration? Remuneration means the basic wage or salary and any additional emoluments whatsoever payable either in cash or in kind to a person employed in respect of employment or work done in such employment, if the terms of the contract of employment express or implied were fulfilled. The second definition of the act is same work or work of a similar nature. Same work or work of a similar nature means work in respect of which the skill, efforts, and responsibilities required are the same when performed under similar working conditions by a man or a woman, and the differences, if any, between the skill, effort, and responsibility required of a man and those required of a woman are not of practical importance in relation to the terms and conditions of employment. So basically these two definitions are most important definitions of the act. First is the workplace, and that means the same work or work of a similar nature, and second is the remuneration. Now, what are the duties of employer? Under the Equal Remuneration Act, employers require to ensure the following to workmen. First of all, no employer shall pay to any worker employed by him in an establishment or employment remuneration, whether payable in cash or in kind, at rates less favorable than those at which he pays remuneration to the workers of the opposite sex in such establishment or employment for performing the same work or work of a similar nature. No employer to comply with the Equal Remuneration Act can reduce the rate or salary of any worker. Also, no employer, while making recruitment for the same work or work of a similar nature, can make any discrimination against women except where the employment of women in such work is prohibited or restricted by a law in force. Now there is one more term, that is maintenance of register. Let us understand what it is all about. All employers require to maintain a register and other documents about the workers employed as per the prescribed rules. Rule 6 of the Equal Remuneration Rules provide that every employer maintain a register about the workers employed by him in a Form D. What are the penalties under the Equal Remuneration Act? The penalty under the Equal Remuneration Act separate into two categories as follows. First is minor infraction and the other is major infraction. So let us first understand what is minor infraction. If an employer commits any of the following offences under the Equal Remuneration Act, a penalty of ₹1,000 can be levied. Now, what are the offences? First of all, omits or fails to maintain any register or document about the workers employed. If an employer fails to do this one. Second one is if an employer omits or fails to produce any register, muster roll or other document about the employment of workers. Then third, if an employer omits or refuses to give any evidence or prevents his agent, servant or any other person in charge of the establishment or any worker from giving evidence, then of course the penalty is of ₹1,000. Then second category is major infraction. What is this? First of all, if an employer commits any of the following offences under the Equal Remuneration Act, a penalty of ₹5,000 can be levied. In minor infraction, the penalty was of ₹1,000, and in major infraction, the penalty is of ₹5,000. Now, in this also, there are offences according to which the penalty is set. Now, what are the offences? First of all, if an employer discriminates in recruitment in contravention of the Equal Remuneration Act. Second, if an employer makes a payment of remuneration at unequal rates to men and women workers for the same work or work of a similar nature. Then makes any discrimination between men and women workers in contravention of the Equal Remuneration Act. Then if an employer omits or fails to carry out any direction made by the government. In case any of the offences are committed by a company, every person who at the time of the offence committed was in charge of and was responsible to the company for the conduct of the business will be deemed to be guilty of the offence and will be liable to be proceeded and punished accordingly. So basically, this discrimination on the basis of sex or gender must be abolished. So this was all about the Equal Remuneration Act of 1976. Thank you so much for devoting your time and listening to my video. If my video was really helpful, then please like, share and comment. And do subscribe to our YouTube channel Lexcliq for more upcoming such videos. Thank you so much and have a nice day.